couple needs to come into the process fully embracing the idea that they're going to have some kind of negotiation that goes on, that they can't come in with one idea and that idea is the only one that carries the day. They have to be in a position to hear each other, and that's where I come in. Sometimes I soften the message, sometimes I make it more clear. Sometimes I have people that one person's the talker and one person doesn't talk at all, so it's really a challenge to get them to a place where they're both somewhat on the same level of communication. It's always mutually beneficial. The people have full control over decision making in the process. If they're successful, they end up with an agreement that is fully within their control. So there's no surprises there. They talk it out. I've been doing this for over 30 years as far as a family law practitioner, and mediation probably 25 years. Usually they have children, but usually that's what they're fighting about. And when I talk to them about the children and they give me their strict structure on how they want things to be, I'll say, well, you know, life ebbs and flows, and you have to have an idea that there's going to be some compromises almost every day when you're dealing with co-parenting and children. You want them to have a safe space, but you also want them to understand that you can't be so structured and strict that you lose sight of the process of raising this child. It's not the only way it's done. There's lots of different scenarios that happen these days. First off, I prefer in person, both parties in the same room. I'm trying to have the parties learn again how to speak to each other in a manner that's going to see them forward after the hard times of the separation and the divorce. But there's other mediations that are also successful in just a different style. There's one mediation called shuttle diplomacy, and the parties are each in separate rooms throughout the entire day, and the mediator goes between the two camps, so to speak. They don't even have to be enemy camps, but they're separate, quiet camps where the party can be with their counsel or not, and the mediator shuttles between the two camps to see if they can reach consensus and reports back. Mediation happens several ways. It happens when the parties, before they file for divorce, they decide they want to have a shot at the most least expensive divorce. And the way you get the most least expensive divorce is to have a signed agreement before you file for your divorce. And mediation's the process, one of the processes where you can come up with that mediated agreement that will satisfy the court requirements for a settlement agreement that's signed by the parties. Sometimes mediation doesn't happen until you're up against a trial deadline, and that's a very common scenario. I think what governs that is people who weren't originally interested in mediation before filing for divorce decide that they maybe would like to have a venue where they can discuss possible options for resolution before having someone that's a stranger to them, a judge, mandate what the answer is going to be, what the rules are going to be, what their life looks like after the trial. The cost benefit is that the parties don't get inordinate litigation fees associated with it. So if you do mediation up front, you're going to avoid all the litigation costs. When you go to a mediator, both husband and wife will each pay half of the mediation fee. They're not doubling up on their lawyers. They're actually getting a lot of what perhaps the lawyers would do in the realm of negotiation cut in half. And all of that is really simplified and cut down when the parties are speaking directly at the mediation table. They don't sign anything, so they're not bound to an agreement reached at the mediation table unless or until they're comfortable with it and they've had their counsel review it.